Okay, so we'll call to order the subcommittee meeting on procedure regarding the Eberhardt versus MOA.
And let me know if you need anything.
Okay, thanks, Barbara.
You're welcome.
I am Amy Domboski.
Bill Evans.
Dave Trainee.
Julia Tucker, Assembly Counsel.
Joe Levesque, Special Counsel to the Assembly.
Great. And our last meeting, we had asked Mr. Levesque to go ahead and answer some of the Assembly, or give us a perspective on some unresolved questions we had. Do you want to give us a status update?
Right. Thank you. I had a chance after our meeting earlier this week to talk to both attorneys that are involved and got some answers. The question that Mr. Trainee had was basically, where's this new assessment and was it ever really set aside? And I think in my email I explained the confusion there, that nobody really has ever set it aside. They just, when they made adjustments because of these inaccuracies that they found, they just said, okay, now this is the new assessment. Yeah. And so, you know, where does that leave us? And what I think is that the Assembly, when it meets, needs to set aside the old assessment.
That's the first action we take when I look at your letter.
Yeah, I mean,
and that's the only one that makes sense because that's still into effect. We have not gotten rid of it yet.
yeah, it's been
We just chose
suspended.
not to use it.
It's been suspended as far as making the payments. So we need to, you know, just set that aside, and we need to vacate. If the Assembly Chair agrees to continue this, then we need to vacate the date that we have set on 7th and 8th of May. And then we have preserved those dates, and so we have to figure out how to use those. Now, one of the emails that I just received, and I was looking at it when I sat down, is from Bob Owens, and he wanted to make a correction. In his letter yesterday, he referred to a 15-day notice requirement for road assessments, but he wanted to point out that when you're talking about the notice for sewer and water assessments, it's a 21-day notice.
Okay.
So, and that wasn't clear yesterday.
Well, I was concerned because Bill, you said we need to give the most time possible to people. So we're not cutting anybody short on it. I would think we need a 30-day notice to let the public know. All the potential claimants and people are going to be assessed. Everybody has the opportunity to come forward and say, it's a good assessment, I'm happy, or no, it's wrong, and this is why it's wrong. So I just want to make sure due process is followed, and we maximum extent we let the public participate.
Right, and are we talking, I mean, I agree that, you know, vacating the old assessment seems to be the logical first step, but is the next step a adjudicatory or a legislative action?
Well, that's what Julia and I were talking about, because there's, you know, the way the Assembly usually does this, the court actually referred to it as an administrative process. But we've talked about it as legislative, and that's where the assessments are provided to the Assembly. There's a public hearing, people come in and comment, and then the Assembly votes to do whatever it wants to do with that assessment.
And if they don't like our action, then they can go to court. Then it comes back for adjudicatory. But in this case, I think you're right. Once we set the old one aside, there's a new one that comes to us. And I don't want the clerk involved in that because that's not her function.
No.
That's the AWW function, to bring the assessment to us.
I guess my question is, in the normal course of things, when you are passing a tax assessment, assuming we vacate this one, it's just like starting over, it seems like to me, with a new one. Is that process typically just in the normal course of the Assembly's actions? That
In the normal
it's
course.
part of the agenda and it's noticed and people can provide public testimony,
Yes.
and then it's passed? And I guess after that, do the affected taxpayers have a right of appeal to the Assembly before they go to the court? I know some places do that.
I'm trying to remember it. I can't right now.
It certainly
But
didn't happen in this
Julia
case.
check it out for us.
So what happened in this case, when you look at what the court wrote in its order, is the court said, look, you know, it wasn't just a matter that the Assembly wouldn't provide, you know, the record that these folks wanted, and it's, you know, it's substantial. But when the hearing was continued, and the chair at that time had told the property owners that they could come in when it was continued at the next meeting and they could give further testimony. Well, then they showed up at the next meeting and the assembly said, no, the record's closed, and we're gonna rule on this. And so there's the due process arguments that these people, are complaining of. So, to answer your question, and Julia and I talked about this, if we could do it all at the one hearing, and maybe that's not the best idea. Maybe the assembly does what it always does, and that is, set aside this one, issue the new one, have it before the assembly. The assembly does what it normally does, knowing that it's going to have this adjudicatory hearing and how that's going to impact people. And if those same property owners that are not plaintiffs in this case want to come to the adjudicatory hearing and they want to provide further comments or testimony, I think the assembly should allow them to do that. But once that's closed, then we start the adjudicatory proceeding.
We could on the 7th have a special assembly meeting and set aside the first one, the first assessment, and then start this process.
Julia?
Because the first one would be set aside.
I think that you're right. I think that you don't have to wait until a special meeting to set the other one aside.
But we don't. But we got the 7th already identified.
But I mean, you can incorporate that into the regular agenda meeting, a regular assembly meeting.
Right,
and
make
just-
it the 6th.
Yeah, and so whenever our next meeting is, I don't have my meetings.
It's the 6th. It's the 6th of April. We could 6th of May.
of-
We could have a special order.
Yeah, or you just put
Make it an
on the-
agenda.
You just put it on the regular agenda as a legislative process that we've now, the chair has convened a subcommittee. The independent counsel has talked with both parties. Both parties agree that the assessment has been revised, that new numbers have been, new allocations have been made, or whatever they call it, the special term. And so the assembly is setting aside that assessment role, and then to allow the administration, to allow the municipality time to give all the property owners notice of the revised assessment. And
Set it back up the normal process.
and then I agree with what Joe put in his note here at the bottom, and also what is in, and apparently the parties each agree in their letters about this, that every property owner is going to be, whether they're an appellant in this case or not, is going to have the right to come and give public testimony about the new assessment. And so that gets scheduled, and we don't know what those dates are, but that will be scheduled, and that could be at a regular assembly meeting. But instead of at the end, I believe that instead of at the end of that, instead of having the assembly approve or disapprove the assessments, they close the public hearing and they continue their action on the assessments until after the adjudicatory hearing is held. Because if you read the court's decision, the court has said that Cheryl in the training notebook highlighted that part, said that because of the flaws here, you can't really, I mean, I read it to imply that you can't, or to state that you don't get to make a decision on these assessments until you hear this in an adjudicatory hearing from these plaintiffs. And if you don't do it that way, then my worry is you start a whole nother appeal track with anybody new who doesn't like their assessment. This way, as Joe pointed out to me earlier, in a different discussion before, in March, is that people dissatisfied with their assessment can intervene or can be added as plaintiffs. And so that way you have that opportunity and you funnel everything to that adjudicatory process. That would be my thought of it.
Go ahead.
And I think generally, I would agree with that, but I think the way I've seen this done in other, like the Kenai Borough and stuff,
Hi, I'm not sure how significant this is, but an email came from Bob Owens. Did you print it already, or have you
But,
seen it?
but we'll give it to you.
Okay, all right.
Thank you,
sorry.
Barbara.
You bet. It was 12:14. I doubt you had seen it.
Thanks.
You're welcome.
Go ahead.
It seems like, I mean, how things should work, in an ideal sense, is that you have an assessment, you put it up in a regular assembly meeting, just like you would any other item the assembly deals with. It's open for public comment. You have your 3 minutes. Anybody affected or even unaffected who wants to talk about it has the right to do it. That hearing is closed. The assembly decides if they're going to pass that assessment or not. But I think they take action on it. They pass the assessment, and then the people who are affected by the assessment have a right to an adjudicatory appeal, a quasi-judicial form before the assembly. And that's where you create your record that gives all the due process rights that the court's going to look for. You couldn't do it in the legislative. You couldn't meet the requirements in a legislative meeting, I don't think, because I think you have to actually take action so that it's more of an appeal.
Right, so that you
There's
actually
something
have
to
an
appeal.
action. So what
Right.
you're saying is, instead of just what I hear you saying is, instead of just closing the hearing, go ahead and have the assembly pass or not pass the assessment, so that you have a decision that's being appealed from in the thing. I guess my concern would be that, and I understand exactly what you're saying, and I don't know how to meet the risk that an assembly member who knows that this has already been gone to court, who knows that there is a record, and that it's been remanded to the court under this decision, is going to feel comfortable making a decision based on what the assessment that the administration says, here's our assessment, and everybody's taken public testimony about. That what the court said was, it seemed to be that at that time, to back up what Joe was saying, is that at the time that those people came in and they had questions, that the assembly should have been somehow doing basically an exploration, maybe even evidentiary of that. And that's all new, because the case law has been that assessments are legislative and the assembly doesn't have to do that. So somehow you got to reconcile a decision by the court that says if you don't make your decision in the context of an adjudicatory hearing and reassess these, then I'm going to take it de novo. And so I'm with you. It's going to take some finesse, I think, in.
Well, maybe
in doing this.
it's a lack. I'm sorry. Maybe it's a lack in the code, because it seems like the code should provide for the review. I mean, the code should provide that once an assessment is made by the assembly, that there is a process for appeal to the assembly, and an adjudicatory appeal that then can be taken to court. But it gives
So I
the.
will look that up, because it may
That'd be
be that
ideal.
the process says.
Well, that's what I was
that it
gonna
goes
ask.
Directly to court, and I meant to ask you if I should. print
Yeah,
off
that's
Title
what I was
19.
going to ask.
So, let me just go get that.
Okay, so Joe, can you help me, because I am
Of course I can.
I am getting a little
Assessments don't get to this.
confused here. So
The worst one.
if we set aside the old assessment, and then you made the comment vacate the date, what did you mean when you said vacate the date? Did you mean vacate the assessment or vacate
The hearing date.
May 7th.
so not have it on May 7th?
Well, on the old assessment.
On the old
It
assessment.
that's-
won't exist anymore.
Well, if we set it aside.
It won't exist.
So my thought was we would still have the hearing, and at that hearing we would set aside the old. Isn't that not what you're thinking?
I don't think you need to.
Just do it at a regular assembly
I don't
meeting.
think it really matters, as long as
Right.
the assembly does it. Nobody's done it. I think the parties really thought the court was gonna do it, and the court
Yeah.
said, nah,
Okay, so
We could do it on meeting the 6th.
sure. My second question, because I'm going to sound probably not as smart as my co-assembly members here,
Don't you
but
ever being smoked, by the way, Bill?
but If we set aside the old assessments, then you're saying we should still have an, adjudicatory hearing. What are we considering then?
Well, that's exactly why Bill's point is so well taken, is because if you do the assessment and the assembly does have it all before them and goes through its normal routine practice, the assembly, based on those comments and on the assessments that are presented to them, may very well say, you know what, this lift station thing is a special issue here, and whether or not it should just be, laid upon these property owners or it should be spread out is something that we need to consider. That's a big point on this appeal. And that could possibly go away. And then so what do we adjudicate? Well, we wouldn't adjudicate that one if the assembly, and I'm not saying the assembly will or has to, but if the assembly just passes it, and the term is like a rubber stamp,
That's a big book.
then the plaintiffs are going to have their same issues. They're still going to argue that a lot of what this work that was performed under this project doesn't benefit their property, and therefore they shouldn't be assessed any special taxes. And number two, that lift station, which was added on at the last minute, it's like $3 or $4 million or something, that they're going to argue that shouldn't be solely on their properties. And if it benefits other properties, I don't know all of this.
So, okay, you have to break it down for me.
Okay.
So you're thinking the discussion of the lift station and whether it should be tacked on to the assessment rolls, that's what's being adjudicated.
That's one of the issues. The second issue is whether or not the construction project, all the work that was done, actually benefited those individual property owners. Because if they can argue that it really didn't benefit,
Benefited somebody else, then why are they being assessed this? Those are their two major concerns, besides the procedural, due process issues.
Okay.
And this may be a question or maybe part of an answer, but as I see it, if the assembly takes action to vacate this assessment that's already been passed, that disposes of, or should dispose of, all the court proceedings.
No, because the court bifurcated some of the issues. And remember, last time I said that the court maintained jurisdiction on 3 of those issues. One of them was the actual bidding process and whether or not it was done properly.
Right.
Because the price for the contract really went up substantially. And they're arguing, well, it shouldn't have been let out in the summer. When you do it in the summer, all the contractors are busy, their prices go up, so they're making all these different arguments. The other one is unjust enrichment and collateral estoppel.
But if there is no assessment, that once that assessment is set aside,
Well,
until it is reimposed,
yeah.
the subsequent one is.
Yeah.
And subsequent one may be different.
It
We don't
could-
even know what it's going to, it doesn't sound like it's going to be substantially different. It's going to
Yeah.
include all those same issues.
Yeah.
Um,
And even the adjustments that were made, there were some adjustments. Some of the assessments were placed in different pots. But at the end of the day, you're still talking about a lot of money for this big project that has to be assessed to some property.
But the other people will have the opportunity, once we pass the new assessment, to determine what we're going to adjudicate.
Yes.
And it could be different than what they have, and it could be more.
A different group of
Yeah.
people.
It could be a different group of people.
But they're going to get an adjudicatory hearing.
Yes. They need to get it somewhere.
And
Sure.
I still think that at the beginning of that hearing, you open it up for public comments. And then you close those public comments. That way, anybody that doesn't want to be involved in the lawsuit, even if they've already given a statement, they can still come forward, or people that didn't make the last one. You just don't want to, you want to make sure that everything is so fair that nobody can complain about the process. The adjudicatory hearing is only for the plaintiffs that have the court action. They have an attorney, and that's
But
how that's gonna
did I hear
proceed.
you just say in the beginning of the adjudicatory process to open it up to even somebody who's not a plaintiff?
Well, yeah.
Yeah.
For public comment.
Right.
Yeah.
I think that should be, it seems like that should take place during the legislative session, before the assessment is
Mhm.
passed. Open it up for everybody, just like you would in public
Okay.
comment. But it seems like an adjudicatory process would only involve those who, after you've passed the assessment,
Have issues.
take issues with it.
Okay.
And everybody can participate in that adjudicatory process as long as they, are basically appealing your decision. There has to be some process for people to appeal, and maybe that doesn't exist, and maybe we can't even do this. Because it seems like that's the ideal world,
Yeah.
how it should.
And either way, that is a good way, but I'm just saying that there's always somebody that's kind of like left out or feels left out, that show up at the last minute.
There's
And
filing fees.
And so for the assembly to just say, well, sorry, you missed the hearing on this, it was 2 months ago or whatever, so we're going to preclude you. I'm just saying, think in terms of really having an open process.
Well, I think the process for how you get yourself into the adjudicatory phase, whatever amount of time after the assessment you're allowed to file your grievance or appeal of it, those procedures need to meet due process standards.
Absolutely.
Maybe it's a 90-day window, maybe it's whatever it is, but if they miss that, you have to be comfortable that your standards meet, so they can't just go to court after that,
Right.
as long as your standards comply
Right,
with
but
due
everybody
process.
needs, and I'm good with that, Bill, especially if the assembly announces, okay, here's our decision, but if anybody objects to it, we are going to schedule this adjudicatory hearing. And we know that Mike Staley's gonna say, well, I still have questions.
Right.
And then if you're saying anybody else that wants to join him or align themselves with him in some fashion, then they can participate in the adjudicatory hearing.
I guess the whole confusion is that there really is no experience with
There's no
history
law.
of doing this.
We don't have that many hearings. We probably have 3 in the 17 years.
This is
of
the
our
first time
assembly.
in the 10 years that I've been here, almost, 9 years that I've been here, that the Superior Court has remanded something to the Assembly
It
to
just
follow
doesn't
an
happen that often.
adjudicatory process that doesn't, one, and secondly, that isn't the process that's required by code.
What
In
is the
code-
process in
So
code?
in code, there are 2 provisions, any irregularity, and the way the code works, the Assembly approves creates the assessment district and approves the roll.
Mhm.
And they can do that separate or in a unified action. And once they approve that roll, then and create the district, then the costs are shared, the CFO gets to do all that, that's what happens.
Okay.
Then it says waiver of objections. The irregularity or invalidity of any special assessment or procedure is waived and may not be contested or questioned in any manner in any proceeding whatsoever by any person not filing a written objection to the assessment roll prior to its confirmation. So you have that, they have a 60-day window. Appeals. The decision of the Assembly upon any objection to the assessment roll provided for in this chapter may be reviewed by the Superior Court, 3rd Judicial District. And so that's 1920.320, appeals. Now that's about the roll. I don't know, in here, and again, Bob Owen has cited to some other, proceedings that I didn't find here, and then you're in there where she listed one process, and then the court talked about what it saw. So there's a gap that the court has done that was an appeal. When Cheryl first looked at this, she wondered how it got here anyway, why they were doing this, and then it seemed to be, and we didn't go through and do the pleadings, but it seemed to be that when Staley, when counsel for the appellants asked for the de novo hearing, part of the objection from the city was that they hadn't exhausted administrative remedies. So the court said, hey, got it, I don't want to do this de novo evidentiary hearing. The city, you've said that they haven't exhausted administrative remedies. By God, here's your thing. When I take 360 and when I take 19 and I put them together, you guys go for it.
Maybe we should tackle this in the simplest way possible, given that history, instead of, creating the ideal system here for this new assessment. If both of the parties, and it sounds like both Owens and Staley, are agreeable to adjudicate this new assessment is what they want to fight over. They seem to be willing to replace the old assessment with this new assessment. To just have the assembly formalize the setting aside of the old assessment, the approving of the new assessment, and then schedule this adjudicatory process with the existing plaintiffs, and go forward with that.
Go ahead,
But
Dick,
if
and
we
then I
do
want to go
that-
back to Julia.
Are we gonna be leaving out some potential applicants that were not members of the roll the first time? I mean, if we institute the other one, is there gonna be somebody out there that says, the burden's been put on to me now, my assessment's changed, I wanna file suit?
I think we have to allow them the time to object as per the code before the adjudicatory hearing is held. So that if there's anybody new that wants to get in after the new assessment, they can still join in.
Let me just mention a couple things. Staley wants 4 months from the time
Yeah.
that the assembly sets aside the old one and deals with the new one, which they should deal with, as Julia has said, and as we've been discussing. He wants 4 months because he said that he has to have everybody has to have adequate notice. And he mentioned, just as Dick was saying, some of the property ownership has changed. They're all lots. They're all like vacant lots, apparently, in that
A great
neighborhood.
view of the inlet,
Mhm.
at least till next earthquake.
And some of those
Better.
property owners have changed. Now, I don't think we need to worry about that because when the assembly, I think when the assembly agrees, if it does, to set aside the old one and then instructs the administration to get that new assessment out and do everything that it has to do that. And then it comes in normal fashion to the assembly again, and then the assembly does, and if I heard you, you're now saying that maybe the assembly shouldn't adopt the new assessment. Is that where you were saying?
I think it has to.
Okay.
I mean, I think once you set aside the old one, you're going to have to adopt the new one
Yeah.
officially.
Yeah, and then just, set a hearing, but, the one point that you made, Bill, that was really good was that the parties, we really need to work with the parties on this, the ones that we have. And, it could be, and I'm just throwing this out there, on the May 7th or 8th days, if the assembly wanted to, it could have some sort of a status hearing with those parties.
That's where I was going to Julia.
And say what, and Julia and I talked about this, and I
Mhm.
think you and Julia had, but that way you get those two parties in there and you say, this is the course of action that we intend to take, and get them to agree on it, and at that time, when the assembly does pass the new assessment, whatever it looks like when after they do that, and we set up this adjudicatory hearing, the parties will tell us how much time they need to present their cases. Because somebody has to have a club. The chair has to have a club and say, look, you said you could do this in, a day or 2 days. And if they start going over that, I mean, we just, this can't be a runaway train.
Julia, can you help me here?
Sure. A couple of thoughts. Before I come back to the.
You know where I'm going. Yeah, you know exactly where I'm going.
Because the court said that this was going to be under 360, then the assembly is empowered to create procedures different than other procedures. And there's a section of 360 in our own code that says that. And so that is something that allows some flexibility to sort of roll your or I was gonna say roll your own, but figure out your own procedure that's going to work for this, because I think that we're not going to find it linearly in the code. It may be important for this group to hold the status hearing first, because, and be able to make a recommendation to the chair to have something that goes forward, whether it's on the 7th or the 8th, because as hard as it is for the 5 of us to digest this, you've had much, even coming in new, you have now had much more exposure, and coupled with your background, that having to have 11 people come up to that. The thing that, what I heard you talking about just a little bit earlier, Bill, was the concept, I thought, of a stipulation. That instead of using the process that's in code for 19, you get to do a lot of things by stipulation when it's under the umbrella of the court. And so if the stipulation is that that the hearing will be based on revised assessments, then maybe you can just step outside the setting aside and the not setting aside and still keep it up.
I think I don't think, I'm sorry.
No, you're fine.
I don't think you can, just because of, otherwise, because we're gonna enforce eventually the new revised assessment, presuming it gets through all this thing. So at some point, I think the assembly has to take official assembly action in voting on the new assessment.
I guess what I would have thought that the assembly took action. Let's put the whole idea about setting aside off to the side for a second. The assembly took action on these assessments. The resolutions are dated 2011, but they weren't passed until February 2012, so they'll refer to as February 2012 assessments, and that was adopted. And then it had a payment schedule. The first payment schedule was going to be due in July or around after July 2013. So when July 2013 came around, the Assembly set aside the initial payment date and said, in light of the fact that the amounts might be changing. So in code, the Assembly establishes the district, sets the assessment roll, and then the roll says, then it says, as I read it, then the costs are sent to that roll. So there isn't any Assembly action that actually has to approve the amount that goes to those people. So the city made an adjustment, and then what Bob Owens has been saying, now that we made this adjustment, you need to send that out, as Dick was talking about in our process, to all of the property owners. And then to go back to answer your question, most of the appellants, but not all of them, own vacant lots. At least one of those appellants had an existing house on a lot that came within the assessment district. It wasn't just confined to a new subdivision. It brought in all this stuff, and he sold that lot, and apparently didn't disclose to the new buyer that there was this assessment, and so he got stuck with $70,000 plus of escrow funds. Okay, and so he doesn't think he was benefited because his property didn't have that street running on the side. It was on the plat.
Mm-hmm.
But why is that a benefit? To him, because when you put in that street, then he doesn't have that for a park in his backyard. So those things, those people are included as appellants. A couple of those people, plus I'm thinking that that the district is bigger because we had that map, and some of those lots have been approved. The Assembly made some individual things when people had appeals about their subdivided lot and all that was going on. So that broader group of people, as Bob Owens, my reading of the code and Bob Owens's letter, forget Staley's, but just the city's letter, convinces me at least that the process says that the broader group of people get to have their legislative process on public testimony about the amounts that were assessed to them, whether they're appellants or not. Then on the rest of the people, the court has said, by God, for these appellants, for this case, you need to do that. So if the merits of the appeal seem to be, for purposes of this section, on the actual amounts that were assessed, and those amounts are not, they're just sent out. The assembly didn't say, okay, we approve this amount. They said, we approve the roll. City, you take care of giving these people the notice. We'll hear the public hearing.
That makes sense to me.
Okay, I've got a couple of things that I just wanted to mention. The first one is that what the court said after it decided that the due process was gone, and I think this is helpful for this discussion. The court said, the court will order that the assembly cannot enforce the current special assessment cost allocations until the assembly reviews the matter again with proper adjudicatory procedures under AMC Chapter 3.60. Cannot enforce. Doesn't mean you can't pass the new roll. You just can't enforce it. If the assembly does not seek to make a new assessment or reassessment of the properties or follow the adjudicatory procedures afforded the lot owners in AMC 360, then a trial de novo may be proper in the future. And then the court goes on to say that Alaska Municipal Code, Anchorage Municipal Code 19, this is the, this judge, Anchorage Municipal Code 1920-340B says the following about the assembly. What the assembly may do when a court finds that special assessments are invalid or irregular. And I think this might be the same section that you just read, Julia. It's
19 what?
It's 1920-340B. It says, in the event that a court of competent jurisdiction orders that any or all of a special assessment may not be assessed or enforced by the assembly because of any irregular or invalid special assessment procedure, the assembly may make a new assessment or reassessment upon the properties specially benefited by the improvement or service by adopting a resolution to make a new assessment or reassessment of the property specially benefited. So then he says, instead of a trial de novo, I think the assembly should reassess the 3 improvement projects costs under AMC 1920-340, which is exactly what Bob Owens is saying, and Chapter 3.60.
And the Chapter 3.60, that's a wrinkle.
That's the wrinkle.
Because how can they do it first and then have it be an appeal when what the court may be saying, Joe, I'm sorry to
No, that's,
this.
go ahead,
What the
Julia.
court may be saying is, okay, this time you're not going to calculate that number until you hear all this evidence about it. And then you go and calculate that number. Or verify that number or approve that number.
And the court goes on to say, then the assembly can decide whether or not any of the costs from the lift station project were improperly imposed on the lot owners. The assembly's reassessment will be done by referencing the updated record the municipality will provide to with an index, as well as allowing the plaintiffs the appellants to review the same record, call witnesses, present testimony, etc., etc. So that leads us back to where we are. I think, Julia, what Bob is saying is the same thing that Bill was saying, is that you set aside the old one, you put in the new one, the assembly does what it does, has the comments.
You build a record.
Yeah, you build the
That's
record.
for processing this. The judge can look at the record, that we took everybody's testimony into account,
Mhm.
and we pass it however it comes out. But everybody gets to testify on this thing.
So now the only question is, of course, that's what we always characterize as the legislative part, because they get to make comments and give their own testimony, but they don't get to call witnesses, cross-examine witnesses, call experts.
Yeah, I guess where I see the difference, and I may have misunderstood Bill, but where I saw the difference between what Bill was saying and what Bob was saying, or at least where I see the difference between what Bill was saying and the way that I read what the court was saying, is that Bill was saying the assembly needs to pass the new assessments and rule on those before there's anything to appeal. And I read the court decision to say, no, you're gonna
Make your new
make your-
assessments.
Make your ruling on the new assessments after you've heard the evidence. And so, I mean, you know, as attorneys, the court's ruling is as foreign to me as it is to you, because we haven't had that in here, but maybe that's where I'm certainly open to a differing.
Well, so then you can marry the two sections, and you can marry them this way. You can set aside the old assessment, you know, have the new assessment, whether you call it a new assessment or a reassessment. Have it on the calendar, notice everybody, let people show up, and don't take action. You continue it until after the adjudicatory proceeding.
Yeah.
That's what you're suggesting.
Well,
That's what
I guess-
Bob's suggesting.
yeah, I guess.
Well, it sounds to me like that's what the court's saying.
I think that it may be that the court has already done that set-aside part of the old one.
Oh, it hasn't.
And it hasn't at all?
No.
Well, not
Correct,
formally,
yeah.
but in the decision, you don't think that what they said was?
No.
No, okay.
No, I mean, it's never been officially set aside. And I think just for
Needs to happen.
clarity of the record, that should happen.
To start this over, it's got to be done.
So I guess where I'm trying to wrap my mind around, because I am not an attorney, so trying to follow all this is interesting. But that's the word we'll use. So back to the adjudicatory thing. I mean, let's talk about if there is a need for a status hearing to try to bring these two attorneys together to make them come together on certain things and give them benchmarks. Are we in agreement that that probably should happen?
I think it should happen.
I think that should happen too.
I don't worry.
Okay, and now let's go to, okay, the potential maybe for a status hearing on the 7th, because that seems like it would be a logical progression.
Mhm.
Are we
Well,
in agreement?
We preserve the date.
Okay, so now let's go to the challenge, you know, just the three of us with two attorneys helping us are having, just
The two
trying
of us
to,
with 3 attorneys here in the room.
oh my gosh, I'm sorry, I forgot.
on
you're
one of
the- Yeah, he's one of them.
He knows the secret handshake.
Oh, so yeah, I was gonna say,
Well, he just gets to have double duty.
oh man.
No, I'm just an assembly person.
This is painful for me, I have to tell you, but, okay. So Julie and I had a discussion earlier today, and I think as I'm listening, I think you're probably right on point that the status hearing should probably be with the subcommittee rather than the whole body.
Because I don't want to bring the whole body up to date on this.
Oh, it's gonna be challenging. So Julia, can you talk a little bit about, you know, the discussion you think, how that would happen?
I'm thinking that, actually, when we were talking, I was talking and thinking fast, and it seemed to me that you could do a couple of things. If you wanted the whole body there on the 7th, then this group needed to have a status hearing before then with the parties and bring them in. But I think or not, and just have it on the 7th. I'm thinking that the 8th, the dates are preserved, but I don't think that status hearing it is going to be the time for people to testify or anything like that. So
Oh,
in
no,
terms
no,
of
no,
being
no.
Just for the two
preserved
attorneys.
with
It's
those notices, I don't
procedural
know
only.
that is. And if it is procedural only, then I think the way to get there is that under a prior AM, when Cheryl was, when the prior independent counsel was working, she explained that Title 3.6 gave the Assembly the latitude to create procedures, and in her experience, and I believe in Joe's prior experience, that's often by code delegated to the chair to just make procedural things on any adjudicatory. Well, we don't have that in code. So what Cheryl suggested is that the Assembly go ahead and give the chair that authority. That's what is to the office of chair, no matter who was in it. So it was Ernie Hall before, and it's now Patrick, to create and approve procedures. And so,
Which is commonly done, by the way.
which is commonly done. So So one thing that could happen is that the group here would outline the procedure, and Chair Flynn would approve it, and that procedure would be the subcommittee will hold a status hearing of the parties and may, request the parties to come forward by a certain date with these items, because in the status hearing, you wanna hold that with you wanna begin that with your end in mind. I mean, what is it that you want them to, what do you want after that? And that's sort of where we've been going here, because in order to find out, to figure out what we want out of what this group wants out of the status hearing, then you also need to know where you're going on the adjudicatory part.
Mhm.
Because whatever gaps that need to be filled in may be helpful to have them filled in the stipulation, because if they stipulate to it, then it stops a
And we could
whole
ask,
group of.
we could ask them to do that. We could even ask them to help us, this is the procedure that we're planning to do. You guys get together and just like the court
Work out
does.
common points of agreement.
Yeah.
Well, yeah, it's
So you know
like
ahead of time.
a schedule, a trial schedule.
Mhm.
It's the same kind of thing. You guys fill that out, bring it to, that'll be the procedure. But get them to agree about this, setting aside the new assessment and then how to do that legislative part and whether to keep, you want to keep the record open, so you can't really close it. And they've agreed on that. They want to keep the record open from here until the end of the adjudicatory.
Right, so part one is, could be public testimony, and part two is adjudication,
Mhm.
and they can be on the same date or not.
Right. But we can talk to them about that.
So Joe,
Works.
when we talk about possibly having a status hearing to try to get them on board, what are your thoughts, and what do you think needs to be?
I think it's an informal hearing that, I think the subcommittee should do it as long as the authority, because as far as what the chair can do or not do, I'm not, that's up to the chair and the assembly. But
Well, you have in your stack for this, the AM,
Yeah.
that gives the chair the authority to make procedural decisions.
then
And so.
you don't have to go
I
back
would
to the
say-
assembly for that then.
No, we don't have to go back to the
Broad
assembly.
enough.
It's just an approval
Okay.
by the chair that would delegate
Okay.
the status hearing ability to the subcommittee.
So you have an informal meeting with them.
Or you could just have the chair reside over it. But I think that what he's looking for is the group to do that.
Right, and
There's
so.
not the time to do it.
Yeah.
So it's very informal. We could do it at any time. The 7th and 8th is perfect because these guys have blocked their calendar for
Right.
those days, so they're both available. And they just come in and sit down with the subcommittee, and I can certainly lead the discussion and answer questions, but get from them, get them to concur that the judge said you cannot. Now what he said was you can't enforce it until after the adjudicatory. So he didn't say you couldn't pass the new reassessment. He actually says you should pass the new reassessment. You just can't enforce it. That's the way I was reading that. So, but just get them to concur with us that this is what we're going to do, and then put our plan of action, into play. So, we'll actually come out with, in other words, a procedural process that will say, here's what's going to happen. The Assembly's going to set aside the old, and I'm just going to make this up as I go along. The Assembly's going to set aside the old one. It's going to hear the new one. It's going to, the revised assessment, the new assessment, whatever you want to call it. Then is the Assembly going to pass that? Take public comment at that time? Or should the Assembly not pass it? Just renotice everybody of the new assessment and then set this hearing date where everybody can come in.
And the value as a non-attorney member in the room, the value to me of having some sort of status hearing where they come in and they sit down with us and they agree to this, it's going to lessen our likelihood of something bad happening in the court from an MOA perspective.
No, you're absolutely correct.
Right? Is it layman's term?
My message to both Staley and Owens, and they're buying into it. They're advocating against each other, but
Sure.
but they want to get this over, and they want it to be done right. And
Right.
so what I've been telling them is what we really need to do is get rid of all the technical procedural issues and concentrate on the merits.
Yeah.
You know, because that's what the assembly needs to hear is the merits of the case, and that's where the decision, that's what it'll cover.
Right. Now, Julia, earlier we had a brief discussion. If this subcommittee did have the status hearing with the two attorneys, what are you still of the mind that we should make the recommendation to the chair, or the subcommittee could determine these are the procedural things that all parties have agreed to, and this is how we're going to do it?
I think that you can do that both ways. So let's, and so I think you might want to check with the chair to
Mhm.
find out how you'd like to have that done. If the chair wants the subcommittee to make the ruling on that at the status hearing and to have that ability, then we would draw up that in a little memo and the chair would sign it and delegate that to you when you're off. If the chair wants to be able to review and approve it, then you just do just like you are now. You don't need that pre-delegation memo, and you make the recommendation back to the chair. I think my concerns about what Joe, the things that come to mind about what Joe is talking about is that I believe that these two parties need a lot of structure. Everything that I've seen so far shows me that it's all loosey-goosey.
Well, and that's why I go back to, should we do it or should the chair do it? Because we're here and we're in front of them and we can tell them,
Right.
you
And
will
but-
do this.
But more than that, I think ahead of time, and maybe Joe can draw it up for you, is the deliverables from this group, I mean, these two, from the two parties, need to be clear. So to me, it should be, we're gonna have a status hearing at such and such a time, at such a date. You can have it right here. You don't have to trot them down to the assembly chambers. And this is the proposal. Outline whatever the proposal is, or these are the points that we want you to agree on and come and tell us where you haven't agreed. But somehow, they have to come in and not be told then what they have to go back and do.
Yeah.
And because they're not gonna agree. Cheryl tried this with them, even on the dates for the hearing. And then when they came back, she just said they didn't stipulate, so they're gonna get stuck with the dates that the assembly picks because they're not stipulating to it. And so, I think they're gonna be much, now that they've seen, they're not gonna go any, I mean, she held firm, Joe will hold firm, but I think that this is people that need structure, because otherwise they're just gonna keep fighting.
But that is the
each other.
purpose of having that status hearing and ending up with a document. Whether or not they stipulate to it or not, we can't force them to do that. But at least if we have input from them and we know, where their objections are, if there are any, and where they agree, then that's gonna give us structure, I think.
Right, I think so too.
Well, and that's part of the reason why I keep going back to, I think this would be far more effective if we kept it within the subcommittee versus the whole assembly, especially seeing what both parties, how information is being given to us.
And it's gonna be my recommendation to Patrick that we have the subcommittee do this, because Patrick does not have the time.
Yeah. Well, I personally concur. I think, what are your thoughts?
Yeah, I think. Patrick-
I think that the three of us as a subcommittee should be able to, because, I mean, we're not making an ultimate decision on the outcome, but we're trying to have structure.
Well, Patrick asked us to give structure to this process. That's why he created this committee.
So,
This gives structure to the process.
go ahead.
What I would recommend is, I would agree with that the subcommittee should handle the status conference. What I would recommend going away from this is to direct a special counsel in consultation with our assembly counsel to prepare a document that outlines the procedures that we want to use going forward to resolve this matter, including timing, days, put the whole package together as we want it. provide it to the attorneys in advance of the hearing, with the instruction that, the hearing is for to hear what their objections are to this procedure that we've outlined. And so that we can, maybe they'll have some good objections and maybe they won't, but that would be the end outcome of the status conference, is that they've at least had their chance to raise objections, we can address them, and so that the process should be
The
fine.
due process.
I agree with that. Do you agree with that, Dick?
Yeah, it's good to have an attorney on.
Yeah, I couldn't articulate it.
Well, I think
so.
as Julie was saying.
That, well, that's it. And then the other thing I would recommend, just listening to the two different paths we could take, I would recommend that Patrick does delegate the authority to the subcommittee to be able to
Right.
make the decision and kind of say, this is going to be our procedure. And
I agree with you, up to the point that the assessment comes in front of the assembly.
Oh, yeah.
It takes the full body.
oh yeah,
But for this, he wanted some structure. This committee gives it structure.
sure,
We can conduct a status hearing.
sure.
We'll have time before the document is sent to the other attorneys to have Patrick look at it. if he
Oh,
wants to see
absolutely.
If he's comfortable.
I'm happy doing that, but do you guys all concur that should be
Yeah,
our part of our purview?
Mhm.
yep.
Okay, so
Okay,
can
we
we?
can do that.
Can you?
Yeah, and then I can put that, if you want me to, you're gonna take care, you're gonna be the lead on the procedures, but on the
Authority.
delegation, I'll put together the memo, I'll put it in draft,
Mhm.
so that, it's not getting the cart before the horse, and you'll have that, and I'll do that as a
Okay.
thing here.
And for the procedures, I'll work on the first draft, I'll run it by Julia. When we're comfortable with it, we'll send it to you first, so you can see what we've come up with. And then we'll send it to the parties and notify them that we have this hearing set.
Then on the hearing date itself, the bar convention is also on the 7th and 8th of May, and I paid to go to a session that is from 3 to 5 here downtown.
On
And
both
so,
days?
I think that it's on Monday, I think it's on Tuesday, the 7th, I think it's on the
The
7th.
6th is Tuesday.
I was gonna say,
Okay, well,
I
I'll
think the
have to
7th
look
is
at
Wednesday and
We
Thursday.
can do it the other day.
Oh,
Yeah.
then it would be Wednesday.
Whatever you want us to, we want to do whatever works for you, Julia.
Well, I was just saying, you shouldn't be doing it for what works for me. I
Sure,
don't
yeah,
know that
you
I
need-
have
We
to
want
be
you
there
to.
for
I don't want to
the,
lose the money.
Just for myself, Julia, I don't want to make you look bad, but I accommodate my schedule to
right,
whatever
he
you guys
does,
need.
right.
Well, we've got those 2 days,
Oh, yeah.
days we set aside for them too, were 5 o'clock to 11, so it was after that, if we wanted to use those times on either day, it's fine.
Yeah, and that's why I say, even if it's at 6 or 7, I don't.
And it should only be an hour. I mean, it shouldn't
If
really.
it's over here, it's really easy, because that gets done at 5.
Yeah.
Yeah, so
And
if
it's
we
right next
if we
door.
did
But
it like
as Joe
here.
says, he accommodates it.
Well,
I'm
if
only
you're-
saying that, I'm only mentioning that it's.
Yeah, what I'm thinking is we've already noticed them for the 7th and 8th. They're all planning on being here the 7th and 8th. So if you have something till 5, if we could just maybe the 7th at 6 be here.
Or the next day.
Or the next
The other
day.
day, yeah,
Yeah.
whatever the alternate days.
Yeah,
I mean-
we have 2 days, so we can check with them to see which day works best for them as well. I don't.
So do we agree that we're going to set aside, one of the things we're going to tell them is, that's our intention to set aside the first assessment? Because I want these attorneys to know up front. We set that aside, we start over again.
Not to add any complexity to this, but when I was listening to Julia read how the assessments and stuff work, it sounded to me like that the Assembly's role is to set the role and create the district. If that hasn't changed, if the role itself has not changed with this new so-called new assessment, if it's only the dollar amount, it doesn't sound like the Assembly has to do anything other than what it's done so far, is to stop processing it.
When the roll comes in, it lists the property and the charge for each property.
Okay.
It tells us how much they're going to pay.
And that's the action that the
But,
Assembly typically
but
approves.
no, the amounts though were set by the administration.
The amounts were revised and set by the administration.
'Cause those
And
could
It
change.
comes to us from AWWU.
Right.
So those may have changed since initially it came to us. It had to have changed because they agreed that some of them were wrong.
Oh, yeah,
So Assembly would have to take action
So-
on the new assessment.
Go ahead, Julie.
Okay. What I understand from since our last meeting, is that one of the attachments that Bob Owens sent to Barbara to show her the property owners of the district, that included the revised amounts to take out of to the property owners after taking out that landscaping that went to Lindberry Park. So Joe's probably more familiar with all this than I am, but when I was talking about a stipulation, it seems to me that this whole setting aside and all that just goes round and round, and what you can do is say that the notice, the important part for them to agree on is that the notice that goes out to the property owners will include these new amounts, since that's what Bob said it was, and then the other side has a foil, has an amount to be arguing against that was used, and we won't get all wrapped around the axle.
So are you saying that it can either be set aside or revised? The assessment can either be set aside by the assembly or revised by the assembly?
I guess what I'm saying is that outside of this hearing and this remand, I have not seen the assembly set aside a prior assessment.
Mm-hmm.
What they do is say, we have changed the numbers, and this is the notice that's going out. And they just inform, they take care of the notice, and they say that it's going out. I'll go back and look at what this court says, because we're under that court order. You read it out. I just don't think the setting aside and all that is, I'm like you, forget the bells and whistles, like what you said to them, let's go to the merits. How do we best get to the merits?
Right. And it may be the revision.
And it doesn't matter what you call it. I think the important part that the parties need to agree on is the notice that goes out that people are gonna testify on, because they have to testify, is gonna be this maximum amount now. I mean, the maximum for the assessment is gonna be this revised amount that has never gone to the property owners.
Right.
Bill, did you have a comment?
Well, just on that, is that once we send out the amount, however we get to it, with the new assessment, it seems like it opens up the possibility of new objections. That unlikely it'll occur, I would think, but.
No, there will be new objections. because-
Somebody's gonna be upset with us.
So it seems like part of the procedures you lay out for these guys going forward has to incorporate the ability of others to
Oh, absolutely.
join in.
And that's
Okay.
where and that's covered,
over there.
would be, I think, covered in two spots. One, as Joe has been talking about, the legislative, they don't lose their right that they would have had to come and testify legislatively on their new amount,
Okay.
okay? Before the assembly approves it.
And we don't know exactly
Or
where that's going to
revised,
be in this
yeah.
process, but it's either at the end, but we can't have it at the end. Because if it's at the end, what's the point of testimony on it?
Okay, so I'm gonna give it back to you.
Okay.
I'm gonna ask you a different way.
Yeah.
If the assembly is gonna consider an ordinance, and they get public testimony that convinces them to change the ordinance,
Mhm.
then they get to change the ordinance, because that's responding
Up
to
to
the
the moment
public
we vote on
testimony.
it.
So that's what the legislative thing is about.
And we've done it before.
Okay. Yeah.
For example, the downtown business district, when we assessed that for that area, there were homes that said, I don't benefit from this. And they proved their point, we dropped them off the tax rolls for that. We did that year after year, remember? Until we redid the downtown business
Yeah, so in an
district.
adjudicatory hearing, I don't think you can make the decision until after the end of the evidence.
Yeah, and then the adjudicatory part.
Right, but the same thing, oh, okay, so on that other part, I don't know, on it seems to me that it would be helpful to have the parties stipulate that these are the notices that are gonna go out
Right.
with these amounts, with this revised, and that this represents, so that you have a baseline to be able to have the assembly be adjusting or not adjusting.
I agree.
And then it'll be up in the, so the notices go out. What I don't know is I just have to think about that.
Well, okay.
The problem is that I'm sorry.
Go ahead.
They're not, they're concentric circles, that the notices go out to a broader swath of people that are participating in this process and are agreeing to stipulations. So the only thing I'm concerned about is to make sure that that bigger group that get the notice, that's not part of our status conference or not represented by anybody, are not going to be a second group of plaintiffs down the road somehow.
That's right, and that was Cheryl's concern also about that. And so, I wonder how the city and Council for Staley, what Joe and I talked about is that they get to intervene. It's already under
Absolutely.
court. This is a remand hearing under court order. And so we're gonna give the public, notice, and you don't have to be a party to be able to participate. But if you're gonna join the appeal, you're gonna have to do it someplace over here.
Right. They just
And-
have to be notified of that in some manner.
And
Yes,
naturally, a
that's what
lot
I
of
think.
people are gonna say, as long as there's people that are fighting it,
Yeah,
you know,
back
I can
and
just
forth.
sit back
Class
and
action.
not, you know, live the stress.
Sure. I have someplace I have to be at too. So I think we have a clear path forward.
Yep.
Do you think by email after you guys have your drafts that we can look at it and basically approve it?
Mhm.
Or do you think we have to meet again
No.
to take that action?
So you need to meet again? You can email everything.
Probably.
Is
No, I
that
don't think there's, I think Julie and I will be meeing.
Yeah, you guys will be meeting, but we're not going to get in any trouble with conducting business outside, are we? Of like a subcommittee?
No. No, we're attorneys and you've given us directions to prepare this document.
Mhm.
That's all we're doing.
And then we can review the document outside of a meeting, so.
I do want to give notice to both attorneys that we're thinking about scheduling something on the 7th or 8th.
The only other concern that I have is, I mean, obviously we preserved the 7th and 8th on purpose because we didn't have some of the information. I have the expectation on the 7th, there's going to be people that show up at the LUSAC library
Mhm.
in order to, so,
Have we sent the notice out to the public?
yeah, it went out on Tuesday.
Okay.
So that's my only concern is,
Yeah, I think that group, I think that you have to tell that group.
send a follow-up letter.
Mhm.
Whoever got this
Follow-up
letter
to say that the
hearing on
assessment hearing
is going to be deferred.
is gonna be postponed and it will not be,
Mm.
or it's gonna be deferred to a date and you'll get a new notice with the date and the procedures.
Does this subcommittee have the authority to say that that's not going to happen on those days?
Well, that's why I want Patrick to sign that thing to delegate our thing, so we have definitely the authority to say it.
Because if they can do that, then Barbara can work on her letters.
Do you see where I'm going? Because there's a lot of
Yes.
decisions that.
Yes, so the first thing is, the assembly does not have to, as a group, does not have to take action on the 7-3. I mean, does not have to revoke that. That was a chair decision, and it can be revoked by the chair.
Perfect.
Or by delegation of this group. And
Perfect.
so Barbara can work on that notice now.
Yeah.
And I'm
about
just-
that, because that needs to go out. And then
Well,
I would
she should do
suggest
that.
that you have the status hearing less formal and not at LUSAC.
That's fine. I just want to make sure that you don't have 150 people show up. at the
I
LUSAC.
agree.
So that's why I say some of these are like little tiny decisions that need to be made so we can do this, and I think it would be valuable for the chair to give us the authority to do that.
Which
Right.
she
So I
says
can
they
write that up.
already have the authority.
Well, the chair's.
No, I said the chair
Oh, the
has
chair,
the
okay.
authority now to make all procedural
Patrick can
decisions.
delegate
And has done a delegation to this group to
Okay.
make recommendations to him.
Sure.
So in the interim, I think that you should make that recommendation to Patrick,
I'll
that
call
that
him.
notices go
And,
out.
Amy,
And
I
also
think-
let him know what.
So the
what his-
notices go out saying that those hearing dates are no good anymore. Whatever that letter is should also be posted at the LUSAC library?
Yes.
On the evenings of the 7th and 8th, so
Yes.
that when people come, there's.
they see something and they don't just plonk. And what I think I'll also do is I'll talk to Patrick first. I'll talk to Barbara second, and whatever letter Barbara comes up with, I will have her share it with you.
Yes, please.
Is that okay?
Yeah,
So
absolutely.
you guys can kind of get a clue as
Mhm.
to make sure, oh, well, you know, whatever, we're covered.
Right, because it was Cheryl who did those, I think that's totally appropriate.
Okay, sounds good.
To have Barbara.
So, the next thing, we'll just be waiting for the drafts of what we think our procedures will be. We'll be watching for the draft of the delegation of authority. Thank you. And then we will be waiting to hear what the parties say after you tell them we're going to have the status hearing.
And you're gonna let Patrick know that you tasked me with
Yes,
doing that that was
Yes.
the consensus of the
Yes.
group for these things.
I will.
I guess one other question before, when it got to the notices, special counsel drew those up for Barbara. Do you want to
Oh,
talk to Joe about this drawing?
well then that would be
The
so
revocation of-
so
that's
much
gonna take a load
easier.
off of her.
That would be so much easier. Could you draft that letter?
Yeah.
I didn't even think about that. Good point.
The never mind letter.
Yeah. Oh well. And promise them, you know, when this comes back up, you'll get a new notice.
Yeah.
That would be great. That would be so much easier because then she just has to distribute.
Yep.
Good call. Okay. It is 1:45 and the meeting's adjourned.